ladies and gentlemen, it's my privilege and honor to welcome you to this evening's panel discussions with the candidates for a judicial position at the International Criminal Court here in The Hague. My name is Kirsten Meerschaert-Duchamp. I'm the head of the Coalition for the International Criminal Court's office here in The Hague, and I'm very pleased to serve as moderator of this event. I'd like to thank the Hague Institute for Global Justice for kindly hosting us here in this lovely setting. We're still benefiting from daylight, so it makes it all the more pleasant. To let you know that this event is being recorded, and the recording will be made available on the Coalition for the ICC's website so that your colleagues and the global community can follow a bit the discussions at a later time. And for those of you who are connected to social media, if you're interested, you can tweet about this event using the hashtag CICC elections, and also using the coalition account tag, which is @_CICC. So for those of you who are not familiar with the Coalition for the International Criminal Court, we are a network of more than 2,500 non-governmental organizations working in 150 countries. And we share in that network aims to make sure that the international system of justice with the ICC as its cornerstone is one that is not only effective, but fair and independent. And our main aims are therefore to see that justice is universal and visible, that there are national laws and investigations at the national level into genocide, war crimes, and crimes against humanity, that there are also aspects of stronger cooperation by states, regional and international organizations, and other actors in terms of helping the court to carry out its mandate, and to make sure that the court operates in a fair, effective, and independent manner. Which brings us to tonight's topic, the elections for judicial positions at the court. As you may know, on 24 to 25 June of this year, the Assembly of States Parties will hold a resumed session, a resumption of the 13th session of the ASP. And at this meeting, the states will elect one candidate to the court. This is to fulfill a vacancy that was left by Madam Senator Miriam Defensor Santiago of the Philippines, who resigned her position last year in June. Due to underrepresentation of the Asia-Pacific region in the judicial plenary, the election taking place in June is exclusively open to candidates from that region. 3 candidates have actually been nominated during the period that ran from February 18th to 31 March. Dr. Ibrahim Al-Jazi of Jordan, Dr. Raul Kano Bangalangan of the Philippines, and Mr. Khairul Haq of Bangladesh. Mr. Haq withdrew his candidacy on Monday, April 13th, leaving us with 2 candidates for the position. Now, before giving the floor to our esteemed colleagues, I would like to just explain a little bit the coalition's campaign on judicial elections. Since the court's establishment, actually, the coalition has undertaken every effort to make sure that the election of all court officials is both transparent and merit-based. And this is because we truly believe that the only way that the court can be credible in the eyes of the world community is if it is independent, effective, and fair in its procedures and trials. And that can only happen if the chambers are composed of judges who are impartial and highly qualified. Today, more than ever, as the court approaches its 2nd decade, and engages in ever-increasingly complex cases and investigations, it's more important that only the most qualified judges sit on its bench. And in an effort to ensure this, the coalition undertakes a comprehensive elections campaign. I should note that the coalition as a whole does not endorse nor promote any individual candidates or oppose them either, but we advocate only for a transparent and merit-based nominations and elections process. And we also must say that reciprocal agreements when it comes to the actual voting process must be avoided at all costs within the international justice context. When it comes to the nomination period, actually, the campaign of the coalition starts well before, and we closely follow and scrutinize the process from that moment all the way up to and including the actual elections. So first, we encourage all states parties to make sure that the nominations that they put forward are of those candidates who are highly qualified, but that also the process at the national level for selecting those candidates is itself a transparent and rigorous process, taking into consideration the key progressive minimum voting requirements incorporated into the Rome Statute, including categories of expertise, the equitable representation of female and male judges, as well as the requirements laid out in Article 36 of the Rome Statute, which I can remind you call for all candidates to be persons of high moral character, impartiality, and integrity, and have established competence and expertise and experience in criminal law and procedure or in relevant areas of international law. Once candidates have been officially nominated, the coalition contacts each candidate, asking them to complete a specially developed questionnaire that enables them to go beyond the formal application process, to delve into their motivation in applying for the position, but as well their experience in dealing with certain issues such as victims, sexual violence, gender equality, fair trial rights, and even the management of large staff. We're very pleased that both of the candidates have completed our questionnaire. These questionnaire responses will be circulated to states parties, to the Advisory Committee on Nominations, and made publicly available on the Coalition's website. As many of you have seen, there's also copies of the questionnaire responses here this evening, so I encourage you to take a copy. We also view our campaign as complementary to the work of the Advisory Committee on Nominations, which we fully support. Indeed, as far back as 2004, the Coalition has urged the Assembly of States Parties to establish this body to make sure that the nomination and election of the highest qualified officials takes place in line with the criteria prescribed in the statute. And since the committee's establishment in 2012, the Coalition has urged states to give it its full support and to take into account the recommendations and findings of the committee. Today, we continue to support the committee in fulfilling its mandate and in further improving the judicial election process. Finally, as part of our campaign, we organize panel discussions such as this one this evening, which we like to think it provides the candidates with an opportunity to expand on their motivation, experience, qualifications, and suitability for position as judge at the ICC, but also to provide you, the audience, with an opportunity to question the candidates on the issues you think are the most pressing and important for international justice and the fight against impunity for genocide, war crimes, and the crimes against humanity. So, without further ado, I will bring you to tonight's panelists, and it's my great pleasure to introduce you to Dr. Ibrahim Al-Jazi from the Hashemite Kingdom of Jordan, and Dr. Raul Pangalangan from the Philippines. Warm thanks to both of you for taking part in tonight's discussions. I'm going to provide each candidate with about 5 minutes to make a brief presentation of themselves, perhaps on your motivation, what exactly drives you to seek judicial office within the International Criminal Court. And I'll start with the person closest to me, Dr. Al-Jazi.
Good afternoon, Your Excellencies, dear representatives of NGOs and various activists in the international criminal justice. First of all, I would like to take this opportunity to thank the Coalition for their efforts and for this honor to be here on this panel. And I would like to thank also Dr. Raul Kanu for this opportunity as well to be on the same panel and to listen and to try and attempt to answer any inquiries or questions regarding the questionnaire or my motivation or the reason that I want to be a judge at the ICC. First of all, I would like to introduce myself. As it's known, my name is Ibrahim Al-Jazi. I am a professor of international law at the Faculty of Law, University of Jordan. So my profession, first of all, is an educator. And as an educator, I believe in justice. Because like on daily basis, I educate my students and my, who come from all walks of life on the main principles of justice. Such a belief, not focusing on a domestic level or a regional level. Now we are talking about like international criminal justice as a whole. And I strongly believe in the promotion of the International Criminal Court since the early beginning of my country when it joined the Rome Statute in 2002, and it took great and courageous steps at the early beginning to ratify the statute itself, and that was, faced with a major challenge at that time, because that would end up the impunity for His Majesty the King as far as the Constitution is concerned. And the government from the early beginning set up an ad hoc committee to harmonize the Jordanian national legislations with the Rome Statute. So from that early beginning in 2002, I was involved in this ad hoc committee, which gave me the opportunity to look at the statutes closely and to work with other colleagues from various departments within the government and within the university and academia groups in order to incorporate the Rome Statute with our national legislation. And I would also add, my involvement with various, human rights and humanitarian law institutes and organizations allowed me also to work closely within the principles of IHL, human rights, and as far as public international law is concerned. I was a frequent speaker and still is in various topics related to international law, as well as IHL and the human rights. With other colleagues from the Arab region, we set up an Arab Academic Human Rights Network, which involves eight countries now, including Morocco, Algeria, Tunisia, Palestine, Lebanon, Iraq, Syria, as well as Jordan. This network, it's not only a virtual network, but it's also an active virtual network, because we meet all together and we set up seminars and training, moot courts as far as the IHL principle, as far as Geneva conventions are concerned, and we've done a number of moot courts competition in the region, and there is a forthcoming competition coming in Algeria in October. So that kind of atmosphere that I live in and I work in as well allows me to strengthen my belief in international justice and criminal justice as a whole. And I would take this opportunity also to emphasize the fact, it is part of our culture and beliefs and religion is to end up all these kind of horrendous crimes that are occurring in the world, and also these kind of challenges that are taking place in the region, and particularly what's occurring lately as far as the extreme groups that's coming up in the region. And I believe that the coalition addressed this issue about how they would, the difficulties or the obstacles that the ICC is facing regarding how to persecute people who work or being recruited by ISIS and other extreme organizations.
Thank you very much, Dr. Al-Jazi. Dr. Pangalangan?
Thank you so much, Kirsten. And just like Dr. Al-Jazi, I'd like to thank the coalition for giving us a chance to present our ideas before this forum. And I'm also honored to be on the same panel as Dr. Al-Jazi. Kirsten, you asked about motivation. And for me, it goes back to my interest in human rights long before I even became a lawyer. I was a student at the University of the Philippines. It was the height of the dictatorship of Marcos, and my university was the seat of the student protest movement. And I protested many of the things, the injustices that the court today has, seeks to end. And by the time I finished my first university degree, I went to law school and I specialized already in I made it a point to focus on international law and human rights. That was a topic of my doctoral work for my LLM and my SJD at the Harvard Law School. And I came to the Hague Academy as well, took the general course with Professor George Abi Saab. And when I came back to my country, I became a professor. Well, I resumed my being a professor and became dean of the law school. I have focused my academic work on both the domestic protection of human rights through constitutional law and the international protection of human rights through international human rights and also through IHL, International Humanitarian Law. And it was in that capacity that I have taken part in the work of the ICRC, and I became the, and by the time the Rome Statute was about to be drafted, I became a delegate of the Philippines to the Rome Conference in 1998. And after the conference for the next 10 years, I co-chaired the Philippine coalition to campaign for the ratification of the statute. And for me, I draw from the lessons of both the democratic movement in the Philippines and likewise the campaign to ratify the Rome Statute. In terms of impunity, it is difficult to explain that Marcos was never held liable for human rights violations in any Philippine court. It took 2 decisions from an American tort claims court to find him liable for human rights violations. And I think my country continues to suffer until today for the failure to bring to closure that dark period in our history. At the same time that there was impunity for the violations under Marcos, I also saw in the 10-year campaign to ratify the Rome Statute the way attitudes evolved within my country. At first resisting the idea of an international criminal court, and then eventually arriving at a consensus that we ought to ratify the treaty. And for me, it is a campaign from which we can draw lessons as we try to get other countries in my part of the world, Southeast Asia, to join in ratifying the statute and making sure that the reach of the ICC eventually becomes universal in character. Thank you.
Sorry. Do you hear me now? Sorry. Okay, thank you, Dr. Pangalangan. This is really meant to be open discussion with you here in the audience, so I want to already open the floor for questions. If anybody has any, just raise your hand. There, we have a young gentleman here ready with a mic to assist you. And if not, I will continue. Okay, while you ponder the questions you will ask in a few minutes, Dr. Al-Jazi, perhaps we can come back to, because you did mention a bit the challenges of a very specific context that we're facing right now, where a particular group, ISIS, is committing what many people see as crimes that would fall under the jurisdiction, at least in terms of the type of crimes that they would fall under the jurisdiction of the International Criminal Court. And that's certainly a challenge because the aim of the Rome Statute is accountability for international crimes. So how would we address the specific case of ISIS? But apart from that, what do you consider to be the major challenges today for the International Criminal Court, and I would say the international justice system as a whole?
I think one of the major challenges that faces the ICC is cooperation. And cooperation, in a sense, in order to end up this process of or the phenomena of impunity, you need cooperation from states all over the world. And when we see, like, that an arrest warrant has been issued, and the president of the related country can maneuver and travel from one point to another, although there are some restrictions and some states are rejecting this kind of arrival for the president or the person who was referred to the court. But having said that, cooperation by itself needs to encourage the idea of the court, because the court faced another setbacks in the eyes of certain states and certain nations. And here I have to be more specific as far as the Arab region is concerned. There were like certain reservations, not only by the governments themselves, but also by people. And we are talking about global justice and international criminal justice. And I think the positive step that, of the admission of Palestine within the ICC gave also a good, message to people in the region and to the world that, the court is taking a step further. This does not mean that, that the case has been referred already to the court, but actually the actual acceptance of membership of Palestine itself, I can see it as a positive step. I think there should be more work on the promotion of the court and in the increasing the membership and to make it more wide. I think this is one of the major challenges.
Dr. Panyalagan, would you like to take on that?
Thank you. Is it working? Okay. For me, the biggest challenge is actually for a relatively young court, is the major shift in approach in ending impunity. It used to be, when I started teaching this course a long time ago, we spoke of state responsibility. And the rules were drafted on the assumption that discipline would be maintained basically through states or through the armed groups. And with the International Criminal Court, actually with most of the international criminal courts, the shift then is to add another form of responsibility, which is individual criminal responsibility. And that changes the ballgame rather drastically. And that is why I still recall in Rome when we were drafting the statute, when the crimes were being defined, and as a professor I felt, oh, they are changing the settled definitions. They're adding elements to the crimes. And the way I would justify that was that they were converting the rules into rules that can be enforced against individuals for violations of the provisions of the statute. It will also entail a change in attitude, that now we choose to enforce liability not through political institutions, but through a court. And a court will have its constraints. It is bound by rules. It might not be as quick as some political agencies. It would have to follow a due process. It will be constrained by rules on evidence. And this is an international court consisting of judges from various jurisdictions with varying interpretations of evidence. So I take it that is the fundamental conceptual challenge to a new tribunal dedicated to individual criminal responsibility. And the other, Kirsten, is the question of legitimacy. If the court is questioned for unduly focusing on one geographical area, then it underscores the principle that it is not enough that the court be just. The court must be seen to be just. And it goes into the legitimacy of the entire enterprise. It also goes into the difficulties. The fact that the court is a court, not a political entity, that it is a passive institution. It can decide only such cases as are presented before it. But I think also that that is a challenge where civil society and the various human rights groups can actually work together to bring to the attention of the prosecutor, the office of the prosecutor, cases from all over the world, so that the work of the court will not be focused on just one geographical region.
You both touched upon the issue of legitimacy and universality. And many people see that the court cannot be considered very legitimate as long as so many states, and even more importantly, so much of the world population is outside of the court's jurisdiction. But you both come from regions of the world where, unfortunately, the representation, the membership in the ICC is quite limited. What do you think is the best way to address this going forward? It's a judicial institution. It has politics around it, which might inhibit many states of joining it. But how are we going to move forward to see particularly more Asia-Pacific states joining the ICC in the years to come?
Kirsten, one lesson I drew, I did the first cabinet-level briefing in the Philippines for the ratification of the statute. And I recall the resistance at that time. And it came from the uniformed services, the military and the police. And they used against me a Tagalog saying, it's like getting a rock with which to hit your own head. We have 2 rebellions going on. And they said, you know, if there was a court today, we would be before that court for X number of encounters. But over the years, that position changed. Part of the resistance was simply ignorance. Another, ignorance of the nature of the court, of the independence of the prosecutor. Another part of the problem was, I call it projection. We have highly politicized courts and highly politicized prosecutors back home. Nobody believes that decisions are really rendered according to rules. And so when we try to sell the idea about an independent court, about a non-political prosecutor out there at The Hague, they don't believe it. And what was the best way to neutralize the opposition? I felt that one was to make sure that the different constituencies resisting the idea were exposed to their colleagues from states parties and their own, like, comrades in arms, sort of telling them that, look, we are your fellow soldiers, and we are not worried about the Rome Statute. Instead of them taking it from this law professor, I guess they would believe a fellow soldier or believe a fellow judge. So before long, we began with only one department on our side, which was the Department of Foreign Affairs, which was attuned to the global patterns and the shift in thinking all over the world. And before long, we had the Secretary of Justice also on our side, because then we had all these training seminars for judges and prosecutors. We would, in fact, invite some prosecutors from the ICTY to speak in Manila. And, but until the day of the voting for the treaty, the last resistance came from the Philippine National Police. But even that was overcome eventually. So I think that if one looks at prospects in my country's neighborhood, Indonesia, Malaysia, and Thailand, I think we have to maintain the dialogue that we have begun, and to keep the hope that eventually they'll come around to ratify the Rome Statute.
Turbulent region, one of the issues that has been raised is joining the ICC, and there were also, like, a lot of refusal to join the ICC in the early beginning, and that's why, as you rightly mentioned, there were like limited numbers of states who, from the Arab states particularly, who among the 22 states we have Comoros, Djibouti, Palestine, Jordan, and Tunisia. But having said that, from the early beginning, as I mentioned in my introduction, Jordan, when it was, the concerns were raised that the king is immune as far as the constitution, the king, persuaded the various advisors and agencies that, we are a tolerant regime, we are not a brutal regime, we are not going to commit, such horrendous crimes against our people or against other people. So we might as well, join, and this is what happened. I think, if I may use the word or the term promotion, I think there need a new promotion for the court, in a sense, to the region. And this would not happen by, by the court itself, per se, because at the end of the day, you need joint forces. And when I say joint forces, it means like, other NGOs, including the coalition. I think there was, a positive role from my humble experience with the International Criminal Law Network in The Hague, and the approach, the Institute of Diplomacy, and I played a role in co-organizing a seminar, a regional training seminar in Amman in 2006. And that included, more than 8 Arab states who came, who are not, party to the state parties to the ICC, and who were interested to know more on the ICC. And I recall at that time, Ms. Fatou Bensouda came and also, supervised part of that kind of training, and other people. I cannot recall them all, but that kind of promotion is needed. That kind of education, and because at the end of the day, as the late Professor Shukri, the renowned Syrian professor, said, usually Arabs arrive late at many issues, including, international law events and treaties, but arriving late is better than not arriving at all. And that was his address when he referred to the ICC. So he was, at that time, he passed away a couple of years ago. He was encouraging other states, including Arab states, to join, because I think, if you look closely at the simple idea of understanding of international law in many states, and including the Arab states, it's say, international law is only for the affluent nations, for the strong nations, rather than weak nations. I think it is also for all, whether weak or affluent, and this we need to convey that kind of message, not only through our faculties, our schools of laws, but also to our leaders and our government. And through that kind of process, I think we might reach to a positive level or result.
Thank you. I'll turn to the audience again to see if anybody has thought of a question that they'd like to pose our candidates. Yes, I see a gentleman here in the third row.
Evening. My name is Gerard Giebels. I'm just a citizen from Den Haag. And a couple of months ago, in this very room, we had a meeting about ICC, quite critical, under the title Human Rights Ending. Then you can imagine what the atmosphere was. Quite critical. To be honest, I'm skeptical as well myself. But in the end, there was a gentleman sitting on the first row. He raised his voice and he said, I am ambassador of Mexico in Den Haag, and I can see a lot of criticism and problems and so forth, but I want to mention this. There are millions and millions and millions of people all over the world who know in Den Haag. There is where they will take care of our bastards, of other people who suppress us and who kill us. So apart from all legal things which are important, and I appreciate the introduction of these gentlemen, I would call those millions of people who have put their hope in the ICC. Thank you.
For that comment. Is there anybody else who wants to raise a question right now? Wes, far in the back. Carrie.
Hi, good evening, and thank you for these presentations. My name is Carrie Comer, and I'm the representative to the International Criminal Court for FIDH, which is the International Federation for Human Rights. And I would actually ask you both to elaborate a bit on your perspectives on the implementation of victims' rights before the International Criminal Court, as well as any relevant experience you may bring to matters concerning victims' participation within the judicial proceedings at the court. Thank you.
Sorry, one more question, Shahzad? Fourth row.
I'm Shahzad Charania. I'm from the British Embassy. Thank you very much for your presentations and for filling in the questionnaires. Thank you to the CICC for hosting this event. Both of you are standing under List B, and that means that you don't have any judicial experience. Now, that's particularly important in a situation where you'll have to be dealing with witnesses, difficult counsel, marshalling evidence. What do you propose as a solution to gaining experience in that field? Do you think that training would be useful in this area, or do you have any other ways in which you would bring yourselves up to speed? Thank you.
Thank you. Some excellent questions there. I think the first two, the comment and the question, are quite related, that The Hague, the ICC, stands as a beacon of hope for billions of people around the world, but particularly for the victims and affected communities. And as Carrie pointed out, the Rome Statute has very progressive provisions on victims' participation in the proceedings. So perhaps this time, Dr. Al-Jazi, you can start with your reflections on that, and also, of course, address Shahzad's question regarding your experience in and looking forward to your experience dealing with particular courtroom issues going forward. Thanks.
Well, thank you, Peter, for your comment, and I join you in your message as far as, like, the court is concerned. With regarding to Carrie Comer, when she asked about the victims' rights, well, my experience with victims is not really practical as far as international law is concerned, but I served for a long period of time as the university counsel. And at that time, I dealt with various complaints from, students as well as, like, staff members and, PhD candidates who travel all over, the world to seek, education, pursue their, diplomas and PhD thesis, PhD degrees. And having said that, in some cases, they were, like, referral to disciplinary, committees, and also, like, dealing with the claimant and defenders and supervising all that process. But that is, like, does not match what might be facing at the court, because it's a different setup. On the other, academic level, since I graduated from Essex University, where I've done, my LLM thesis in international human rights law, and I've done my internship with the Egyptian Organization of Human Rights in Cairo, and with the Arab Organization for Human Rights. And at that time, and it was a turbulent time during Mubarak, that was in the early 90s, I had the opportunity to meet, a sufficient number of torture victims by the Egyptian authorities. and I've done my thesis on the work of the Egyptian organization. Through that, I had the first encounter with real victims, and I concluded their testimonies, and I did not use all of that. I don't claim that I used all of that in my thesis, but it was such an exposure for me at early stages. At the later stages in 2012, I dealt with other, real victims with the Freedom House project, Torture Never Justified. And that was like, working as a consultant with the Freedom House on a project that covered 4 countries. That was Tunisia, Algeria, Jordan, and Egypt. And all of these countries, were, touched in a way or another by the Arab Spring, particularly what, I arrived to Algeria, and Tunisia after the Arab Spring or during the Arab Spring. It depends how, if it ended or not. That's another political dimension. But having said that, I also met, because the program by itself, I had to get, to know other, torture victims from these countries. That would bring me to Shahzad's question, in a sense. Do I need training, or do we need training as List B? I strongly believe, with that kind of experience is not sufficient enough to deal with victims, but it would give you, a way of understanding. But I think there would be, if there would be more, exposure and more training on that particular issue, that would be much better. In my other capacity as a Minister of Prime Ministry Affairs at the government of Jordan and as the Minister of Justice, I dealt with, certain serious complaints by victims. And I cannot, I don't have that privilege of disclosing the case, but I can give, a small or brief description. And on one of the cases, that there was a person, a young chap, 19 years old, who was, who died in the custody of one of the cells of the security agencies. And the government of Jordan took that seriously, because that was complaint directed, submitted to the Prime Ministry, and as within my mandate, the Prime Minister referred the matter to me, and I had to investigate in this case, and we had to go to forensic science and to pursue this matter. And at the end of the day, it was solved. But that sort of complaints I've dealt with. Other victims not have to be like total victims or IHL, but or something to do with the core work of the court, but other like maybe financial complaints, fraud, or if they feel that there was like misconduct of justice, and they might seek, thinking that if they seek the royal court or the prime ministry, they might get an answer. So we had to do certain investigation in that regard.
Kerry, your question on victims' rights. I encountered, actually it was at the Rome conference in '98 that I encountered for the first time the power of the victims' rights approach. And that was on the debate, in the debate on forced pregnancy. The resistance came from the Holy See, that in effect it would use international law to legalize abortion in domestic jurisdictions. And you can imagine I come from a predominantly Roman Catholic country, and therefore our instruction was to block that by all means. And the Holy See had a very powerful argument. They said that, if all you wanted to do was to punish that crime, then there is a catch-all provision. That is enough. From a purely prosecutorial standpoint, indeed that was correct. And I thought, in fact, that the argument would win the day until one afternoon there was a panel of the victims of forced pregnancy. And they said rather powerfully that, well, that prosecutorial standpoint is fine if all you wanted to do was to punish. But we, the victims, feel that part of the justice that we want is for the global community to make sure, to tell us, to assure us that what was committed against us is condemned by by humanity, and that it should be punished by the name, by a name that accurately reflects what was done to us. And I felt, that is my opinion, I felt in fact that that was the forum which was a turning point in the debate, and eventually we ended up with a codification of the crime of forced pregnancy. But after the Rome Statute, we actually encountered the same debate all over again in the debate on the comfort women in the Philippines. That initially the term used by the UN to characterize what happened to the comfort women who were captured or lured into the camps and kept there to be, well, they were raped systematically every day for the duration of the war. The crime used was slavery because it was jus cogens. And as a jus cogens, it was the safest legal handle. And the comfort women in my country said, but you know, the slaves are those who are forced to build railroads. The kind of slavery done to us is of an entirely different matter. And here the lawyers started debating. Well, we can't weaken the jus cogens character of the prohibition. But eventually, anyway, I'll jump to the end. Military sexual slavery is a term that is used. The crime is the jus cogens crime of slavery, and military and sexual are adjectives to define the kind of slavery that was practiced. So this is the for me, 2 episodes where I saw the power of victims' rights. On the question about courtroom experience, from our colleague from the UK, in the Philippines, our setup is such that professors actually are expected to practice. And in fact, I teach at the National University. We are the only faculty with full-time professors. All the rest start their day at 5 o'clock in the afternoon. All the way to their deans. Actually, they don't even carry the title professor usually. They prefer the title attorney. But having said that, I'm a full-time professor, but I still do practical work. So I was for 16 years the part-time registrar of the Asian Development Bank Administrative Tribunal. And the first president of the tribunal actually was from the UK, Eli Lauterpacht. I was based in Manila, Professor Lauterpacht in Cambridge, and I just fixed my my working schedule according to Cambridge time. And as executive secretary, that was the formal title of the court registrar, I made the first draft of the rules of procedure. I designed the case flow. I designed a way to work with international judges scattered all over the world while I was based in Manila, and where they would come to Manila to adjudicate. I worked with the leading international law experts from France, Brigitte Stern, from Finland, Martti Koskeniemi, and from Japan, Shinya Murase, now of the International Law Commission, and Yuji Iwasawa, who was the former chair of the UN of the Human Rights Committee. I was also domestically, I was the lawyer against the President of the Philippines when she declared a state of emergency, and the first person arrested was the leading public intellectual in the Philippines, a professor, a colleague in the sociology department, Randolph David. So the case was titled David versus Arroyo. Arroyo was our president. And so I handled that case from the beginning. Arroyo was arrested, David was arrested the same morning that the emergency was declared. By lunchtime, I was at the military camp where he was detained, and I began working on the case. That way, we won the case at the Supreme Court, which nullified the power of the president to to engage in warrantless arrests and in censorship. The Supreme Court has also asked me to be amicus counsel in a number of cases: the impeachment of the Chief Justice of the Supreme Court, and some international law issues, the Japan-Philippines Economic Partnership Agreement, and the characterization of our continental shelf. I was also counsel in a case on reproductive health. Again, as a predominantly Roman Catholic country, our very traditional and conservative clergy opposed access to contraceptives. And I and a group of my former students, actually, filed a case against the city of Manila, which banned access to contraceptives being distributed in government clinics. I also chair a national coalition of lawyers for public interest practice, and we have filed test cases on impunity, on corruption in various courts and administrative agencies. And just to show the blending of the academic and the practical. Between 2006 and 2009, the biggest human rights problem in the Philippines was extrajudicial killings. And the UN Special Rapporteur came to Manila, Philip Alston, my former LLM thesis advisor. And flowing from that inquiry, I did research on the use of cell phone evidence to keep track of victims of extrajudicial killings. In other words, the desaparecido problem has been a problem of the Philippines for a very long time. We actually invented our own term for it, which is salvaging. Well, I imagine in the early days when they were looking for where the bodies were buried, they asked for the guys engaged in looking for and salvaging scrap metal. But salvaging, which emerged in the Marcos years in the 70s and early 80s, I think must now confront the use of cell phones. And well, in my study, I identified cases for the kinds of information that can be derived from either the phone or the telecommunications company, the stuff for which we would need a warrant of arrest, and the call data, which is actually existing in their databases even without the access, even without a prior issuance of a warrant of arrest, but which can eventually be accessed if a warrant is subsequently issued. So using that case, I would say that the academic blends, the academic research on these cases, on call data, the issue of call data retention, then blends with a more practical needs of keeping track of a person who has been disappeared.
Other questions from the audience? Here in the front. Janet?
Hello, my name's Janet Anderson. I'm a journalist and a trainer of journalists in this field. I wanted to know from you what reforms you think might be needed at the ICC.
Okay. Is there another question before I give it back to the panelist? No. Okay. So who wants to take that one first? Dr. Aljazi?
I failed to mention to our colleague from the UK that with one of my colleagues at the government, Minister Ayman Aoud at that time, we concluded the extradition agreement of Abu Qatada at that time. And that was a very high-profile case and very sensitive to the UK. But you know, Jenna, back to your very important question. In an ideal world, you know, if it was down to me and from my you know, ideas, I would like to see too many things, you know, omitted from the statute. You know, as far as the, the rights or the excessive rights of the Security Council, if it was down to me. But we are not living in an ideal world, and we have to, be realistic in some sense as far as the this approach is concerned. But I think, that would not really occur as far as the amendments are concerned without, the broad membership of the ICC itself. Because without that, we cannot move forward. We cannot, ask other, nations to condone the work of the, and accept the work or the mandate or the jurisdiction with the court without being, part of the court itself. But amendment, means that, not only about I would like to see, more, flexibility as far as the complaints are concerned from the victims, because in the victims, it is within the scope of the jurisdiction of the court. If we enhance that, and give it to various victims, whether they are, under the jurisdiction of the court or not, that would, give opportunity for people at least as a platform to come to, forward with their complaints and to highlight it. Whether it's going to proceed or not, that's another issue, but it's also give them that kind of window to see and to explore their own, tragedies. I can see, other issues regarding, the appointment process, and I think, the coalition played a positive role by enhancing the advisory nomination committee, because at that time, for a period of time, it was not, efficient enough. Now it is more active, and it's taking a role, and it interviewed both of us and grilled us for an hour or so or more, and that was such an intellectual kind of grilling. That's what I would like to say for this.
There is a part of the ICC's work for which I think I can draw lessons from my country, which is the problem that the work of the court can be rather slow and painstaking, because one has to be careful in establishing guilt. There is the element of due process, but at the same time, it can take much more time than perhaps we can afford. And in my country, we have confronted this problem of docket management, of streamlining the presentation of evidence, of sparing ourselves there's a courtroom process, almost a ritual, of authenticating a certain piece, a certain document. Stuff that can actually be dispensed with properly and without violating a due process through various mechanisms that we have tried out in our jurisdiction. We call it the pretrial conference, where the parties of the counsels for both parties sit down, look at the evidence, look at those which can be covered through stipulations, look at those which, the documents that need not be authenticated too extensively. And so that the actual trial, or if I should say the actual courtroom drama, will be limited just to the main, to the key issues and the key elements that would have to be established. By doing that, we satisfy both the requirements of fairness and due process for the accused, but at the same time take practical and effective measures to make sure that the process moves forward a bit faster.
Their volley to the floor. Okay, here, Emmanuel.
Hi, my name is Manuel. I'm from the Peace and Justice Initiative. I had a question. There's been recent criticisms of the UN Security Council and a lack of political support behind the situations that they've referred to the ICC, particularly Darfur, and increasingly with respect to Libya. I wanted to know, what do you think is the right relationship between the UN Security Council as a political body and the ICC as a judicial institution? Thanks.
That's a loaded question. So I think we'll just give that one right back to the panelists, please.
I asked Dr. Al-Jazi if it's okay if I took the first crack, because I think it's not fair if you always have to answer first. Okay, you're right, Kristen. It's a very difficult question, which has, I would say, bedeviled the drafting of the Rome Statute from the beginning. The working relationship, and that relationship is defined in various, actually not just between the court and the Security Council, but between the court and the UN. It's scattered in various provisions. Up to there's a provision on the 12-month stay of proceedings upon request of the Security Council, so that there will, if there is a prospect of a political settlement of a dispute, there is the role of the court vis-a-vis the Security Council in the definition of aggression under in the Kampala amendments. But I think your question is more about the ideal, what ought to be the relationship between the court and the Security Council. And of course, the ideal is one of total independence. Otherwise, we create a court, and yet we enable a highly political entity which makes decisions not on the basis of rules, but on the basis of, well, politics and other elements, and where there are unelected members who hold permanent seats. And I think that's a decision, two modes of decision making, which are completely incompatible with one another. We struggle to reconcile the two, in fact, most sensitively through the Kampala amendments, but still, if the question is the ideal that we should aspire for, then that ideal is a complete separation.
Actually, the question of Mamo is, in a way or another, is related to Jana's question, earlier question, in a sense, because, like, it revolves on the relation, between the Security Council and the court, and in ideal situation, as I earlier said, it should be, separated, and we have, like, total independence as far as the court is concerned. But you cannot also turn a blind eye that there is a key role for the Security Council to maintain peace and order in the world, and to maintain, international peace as far as the world community is concerned. So there should be a kind of, role as far as at least the referral issue is concerned. But I have my own reservation on order as far as the 12 months rule is concerned. That I think that rule should be, omitted, because this is a very sensitive issue, and it can be, an obstacle, and it is like a kind of, like, an arm used or a weapon against the court, in a sense, and it can be constrain the role of the court by stopping the procedure or the prosecution, and I think this is one key provision that should be omitted.
Thank you both. I had seen a question in the back before. Matt?
Thank you very much, and good evening, everybody. My name is Matthew Cannock. I'm also Senior Legal Officer at the Coalition for the ICC, so somewhat cheating by maybe taking the floor after Kirsten. But I had a question that's burning in my mind, and it's to do with the expediting of the criminal process and the trials before the ICC. And what I'd like to know specifically from both candidates is what rules or amendments they would make currently to the court's proceedings, but statutes or procedures or anything like that that would expedite the proceedings, or perhaps any practices that are now in place at the ICC that they would change, and any other measures they think could be taken to expedite proceedings at the ICC. Thank you.
Okay, is there another question before we let the panelists address this one on expediting the proceedings at the court? And I don't see anything. Okay, Dr. Pangalangan, would you like to start?
I already answered your question partially when I addressed the earlier question on streamlining the presentation of evidence so that it does not take too much time. And I think that since this is an international criminal court, it is important to streamline that stage of the presentation of evidence, because that is the core of the proceeding. Because after that, after the facts have been established, the appeals would, I suppose, revolve around questions of law, for which then, if the problem is delay and the slowness of the proceedings, is something that is easily addressed by, again, making sure that the deadlines for the comments, the comments, the replies, and the rejoinders would be filed, expeditiously, and that the matter can be submitted for resolution, and that there can be fixed deadlines for the resolution of these cases. But that is for the stage which depends purely on the exchange of written pleadings and memoranda. What is more important for me at this stage would be streamlining the stage of the presentation of evidence, because that is what can be time consuming. It will take careful spade work at the level of the prosecutor to put together the evidence before the filing of a case, so that by the time it reaches the court, the evidence has already been prepared and vetted at the level of the prosecutors.
I think I don't have much to add on this after what Dr. Kano rightly mentioned. So I share his worries regarding the stage of evidence at the court. I need to elaborate no further on this.
It's been touched upon a little bit, but I'd like to go into further detail, if I may, since I haven't seen any more hands raised yet in the audience. Historically, I think many of the worst abuses in cases of conflict have been suffered by women and girls. And unfortunately, their situation is often overlooked and marginalized, and certainly not taken into specific account with due attention given to their very specific plight. As you know, however, the Rome Statute and the International Criminal Court does take a more progressive view of victims of sexual and gender-based violence. Perhaps you could give some examples of any experience or expertise you may have in addressing those particular types of crimes in your past life. Let's put it that way. Thank you.
Well, actually, I have a little experience in this. When I was holding the office of Director of Legal Affairs at the university, some complaints I have received by staff members or students about sexual harassment in very limited cases, but it occurred unfortunately in many work environments all over the world, and universities are not far from these kind of complaints, and we took it seriously, and and we took the harsh measures against those who committed such harassment. Other issues regarding also gender, from a gender perception, it's important to note that the university as a educational institute needs to be also fair as far as principles are concerned and as far as treatment is concerned. And one of the things that I pride myself on doing actually is attempting and succeeding in modifying one of the bylaws of the university, where we had female PhD candidates, male PhD candidates, they used to benefit from the insurance of their they benefit from the insurance, medical insurance, if they travel and pursue their education outside of Jordan, and their wives will also, or spouses will also benefit from that. But that was not applicable on the female candidates for some silly reason, and then we proposed an amendment, and it occurred. And it touched on various issues as far as insurance is concerned as well, and we managed to amend it. So there are some technicalities, legal ways, some amendments that can also help. And at the university, during my stay, which I served for 8 years as a legal counsel, I attempted and succeeded in many reaching a positive result as far as these amendments are concerned. And also I looked at also equal opportunities for my students, candidates, to pursue their education. I am currently the Dean of the Faculty of Law. 65% of our students, we have 1,200 students, are female. And most of them graduate, and now they are joining the workforce in the country. But very few are encouraged to pursue their postgraduate education outside of the country, for whether it's for social reasons or marriage or other engagements. But we try, and personally I try to promote certain opportunity, or to pave the way for them to pursue such a higher education.
When I handled the case on reproductive health, access to contraceptives, and I spoke to the women petitioners, I discovered that there was a link between access to reproductive health and our law then, our new law now, on violence against women and children. And it was that one imperative for the women petitioners to ensure that they had access to contraceptives was that when they refused sexual congress with their husbands, that they were prone to be beaten up. And from their accounts, I learned that there was actually, that despite the law against violence against women and children, that they stood that danger, a completely invisible threat coming from lack of access to contraceptives. The other case relevant to your question, Kirsten, is a case I handled as a very young lawyer. I prosecuted the first sexual harassment case in my university against a psychology professor, and which leaves me with two lessons. The first is on impunity. After he was found guilty, he was the penalty was reduced from removal to a 1-year suspension. And 20 years later, he did it again. So this reminds us about our larger campaign on impunity, that it is important that a verdict be carried out and that it be honored, and that we do not let ourselves be distracted from the fundamental question of moral culpability. The other is, and I go back to a theme I developed earlier, the importance of calling a crime by the correct name. Because when he did it again, and the element of recidivism, you know, the fact that if he is a repeat offender, there is a heavier penalty. His defense was, hey, 20 years ago, we did not call it sexual harassment. We just called it generic misconduct. And indeed, he is correct. From a narrow technical legal standpoint, he was not a recidivist. Because the first time around, what he did was called generically as grave misconduct. And it was only the second time around, 20 years later, that it was already by that time called sexual harassment. So although the case by no means can match the scale and gravity of the crimes being heard by the ICC, it does affirm two fundamental principles that I developed earlier, which is that the need not to lose sight of the campaign against impunity, and second, the importance of calling a crime by its name, and this time not solely because we assume the victim's perspective in looking at the crime, but this time even from a purely prosecutorial standpoint of calling a recidivist as a true recidivist.
Thank you for that. So last opportunity for those of you in the audience to ask a question, as we're soon running out of time. I see one more hand up here in the second row.
Thank you for giving me this floor. I would like to ask a very simple question. What do you think is the most important thing as a judge, not as an academic professional? What is the most important?
I'm sorry, could you ask your question again?
What do you think is the most important thing as a judge, not as an academic professional?
So what do you think is the most important thing if you're a judge, not as an academic professional? That's the question. Would you like to start, Dr. Pangalangan?
Thank you. Thank you. Thank you, Christine. Well, the first virtue of a judge is to be just and to be fair. And that is why it is the foundational ethical guideline for a judge to make sure that if he will render a verdict, that he should be fair to the parties, he should be independent of outside parties, and that he should be capable of rendering a fair judgment according to the facts presented to him, the applicable law, and to his conscience. And that is why if, for instance, the judge feels that his participation in a case might be misunderstood, or it might cast a cloud upon the impartiality of the proceedings, then I think he owes it not just to himself, to the parties, but also to the tribunal as an institution to recuse and not to participate.
To the point of the gender perception, because it's an important issue. And I recall at the University of Jordan, during my term as a director, we issued various decisions of sacking those, professors or other, faculty members or students who committed such harassment. And it was for professors in few cases, they also lost all their money savings as far as the or belongings as far as the university is concerned. So it was taken very seriously by the administration, and in few cases, because it is an administrative decision, it was challenged by the administrative court, and it happened to be I wear another hat, which is also the lawyer of the as far as my law firm is the lawyer or who defends the University of Jordan in many cases, and their appeal was turned down. So they lost also their cases before the court, not only at the university level. Back to the question of the gentleman, I believe, a judge should be, fair and square. Particularly, needs to be, obviously, the aim is to achieve justice. In achieving justice, you need to be honest, direct, and also impartial.
We're very close to the end now, so I would just like to give both of the candidates one last opportunity, perhaps, for some concluding remarks with a question that I'm putting to you as food for thought to include in there. So if you're elected judge to the International Criminal Court, what is one accomplishment you would like to be able to look back on with pride, let's say, once your term comes to an end down the road?
Thank you for this opportunity. I mean, if I become a judge, and then, that would be a great honor also for me and for my own country, and it would be, really beautiful and nice to see all this, perpetrators, before me in the court, and that people feel that the ICC is really fully operational, and those perpetrators are punished in due process.
Kirsten, that is a difficult question. A judge at some point is just a technician called upon to apply rules upon a set of facts. But I recall the favored metaphor of the mason asked what he was doing. One guy says he's putting one brick on top of the other, and the other guy says, I'm building a cathedral. And to honor whichever god the mason worshipped. And I think that in the minutiae of the technicalities of the work of a judge, the satisfaction in the end will be the sense that one took part in a larger project, in a project to end impunity through a mechanism which is an international criminal court, and through which in the end, one's larger values will endure long after one has left the court or one has left the scene. I still recall the moment when in Rome in '98 when the voting was done on the statute, and I don't think anyone thought that actually there would be enough votes to establish the court. And it was done at the FAO in Rome, and one voted by flipping the lights. And I still recall the moment when everyone voted and the lights were flipped. We were all looking at the screen, and for a moment there was stunned silence. It was all predominantly green, and people for after a split second said, "Hey, so we do have a court, huh?" And I think that is a moment that I can still feel today, many years later. And assuming I am fortunate enough and blessed enough to have a chance to take part in the actual work of a court, in the end, I would like to leave it with a sense that I took part and had a small contribution to that larger project.
Thank you. I would like to thank both of our panelists this evening, Dr. Aljazi and Dr. Pangalangan, for your participation in this discussion and for your assistance with completion of the questionnaire and the Coalition's campaign as a whole. I can only echo what you both said in terms of reflecting on a possible contribution to international justice looking down the road. And the Coalition for the ICC as a whole, of course, would like to be part of that process. This is our 20th anniversary, and we look forward to seeing the court become a stronger and fairer institution in the next 20 years. Hopefully, well, definitely with one of you at its side, at least for some period going forward. I'd like to thank also all of our members of the audience for coming to this session and for your questions and comments. And please visit our website in the coming days as this video will be put up. There's more materials at the desk. I wish you all a good evening.